Hey there, estate planning attorney Paul Rabalais here, and in this video I'm going to give you 26 provisions that you may want to consider including in your last will and testament. Alright, so not too long ago I did a popular video where I described 8 things that you should not include in your will, or 8 things that should be excluded from your will. A lot of people watched it, a lot of people commented. I'll put the link up there so you can check that out. But in this video I'm going to describe 26 provisions that you may want to include in your last will and testament, or as I'll refer to it as your will. Now, I will be the first to admit 26 different provisions sounds like a lot of provisions, and I will be the first to admit that as far as estate planning goes, sometimes simpler is better. But the problem with being too simple is that we don't know what's going to happen from the time you sign your will until you pass away, which could be 5 years, 10 years, 20 years, 40 years later. So we're going to cover some of those contingencies that might occur from the time that you write your will to the time that you pass away. Now, I could include a lot more than 26 provisions that you should consider putting in your will, particularly if I wanted to address some of the relevant estate tax provisions, generation skipping transfer tax provisions. But those unique tax provisions are really for the wealthy, and this video is really for you kind of Main Street America folks. So 26 provisions to include in your will. I'm gonna go kind of fast. Here we go. Number 1, state that it's your will. Sometimes when people do their own will, it's not real clear whether they're actually making their will. So there should be a statement. This is my last will and testament. Number 2, your will should revoke prior wills and codicils. Codicils are like an amendment to the will. So if you don't revoke your old will in your new will, and there's something in your old will that you didn't address in your new will, there's potential for conflict there. So virtually everyone, when they write a will, they revoke their prior wills and codicils. Number 3, I'm going to give you this kind of magic bullet phrase that sometimes works really well in wills. It's where someone says they leave their estate to their descendants per stirpes. Those 3 words, descendants per stirpes, like I said, it's kind of a magic pill. If you don't use that phrase, then lots of people want to say, I leave it to my children, but if any of my children die before me, I leave their share to their children. And if any children of mine die before me and they don't have children, then their share goes back to my other children. So you can get around all that complicated language just by saying I leave my estate to my descendants per stirpe. So be aware of that. Number 4, if you do leave things to children, or sometimes people say I want to leave X dollars to each of my grandchildren when I pass away, you really need to address whether that covers children or grandchildren who are born after the will is prepared, or quite frankly adopted after the will is prepared. So it's those afterborn or after adopted children and grandchildren that need to be addressed in your will. Number 5, a lot of people, blended families these days, their spouse, they have or they don't have children, but their spouse also has children, and people want to leave things to their spouse's children, also known as their stepchildren. But you have to specifically mention them. Just saying you leave things to your children is not going to include your stepchildren that you haven't adopted. So you want to make sure you provide for those beneficiaries the right way. Number 7 is kind of popular in the last decade or so. It's these provisions for pets. And when we talk about pets, there's really 2 areas. One, it's how do you leave ownership of your pets? Who do you leave your pets to from an ownership standpoint? Or it's, do you leave money to a pet trust so that you can designate a caretaker for the trust and a trustee to handle the money, and that money's handled to take care of the pet for the rest of the pet's lifetime. And then when the pet dies, any remaining pet trust monies go to the individual or charity, maybe your favorite pet charity that you select. So provisions for pets are number 7. Number 8 is a specific bequest of your home. A lot of married couples say, you know, if I pass away before my spouse, I want my spouse to own the home. They can do what they want to with it. They can sell it. They can go buy another home. They can downsize. I want to make a specific bequest of the home, either to a spouse or to a child. Maybe a child doesn't have a home and you want to make sure they have a roof over their head when you pass away. So number 8 is that specific bequest of the home. Number 9 is if you leave something to someone, whether that distribution is to be made what I call outright or in trust. Grandpa may want to leave $100,000 to his 19-year-old grandson, and then Grandpa needs to decide, do I just let him have the $100,000, or does Grandpa say, when I pass away, I want that $100,000 to go into a trust so it's not all dumped into the 19-year-old's lap? And Grandpa would name a trustee, and Grandpa would customize the provisions of that trust so he would determine what the money could be used for and when the grandchild could get his hands on it, perhaps at a certain age or in certain stages. So number 9 is whether a distribution is outright or in trust. Number 10 is if you're married, whether a specific distribution is to be made when you pass away, even if your spouse is alive, or only if your spouse is deceased. Maybe you want to leave $50,000 to each of your grandchildren, but if when you pass away your spouse is still alive, you don't want that to go to the $50,000 to go to each of the grandchildren, because you want your surviving spouse to have access to all of those funds. So maybe Grandma and Grandpa both put in their wills, I leave $50,000 to each of my grandchildren, but only if my spouse is deceased when I die. That way the surviving grandparent makes that bequest. Number 11 is how to handle tangible personal property. We get a lot of questions. How do I handle the fine china, my diamond engagement ring, my gun collection, those non-titled personal items? Some people, when they really want to make that official, we actually describe those things in the will and we provide for who they go to, but that's not typical. What is typical is perhaps a separate informal writing. States vary whether they honor those separate tangible personal property memorandums, but how to handle the perhaps valuable from a fair market value standpoint or a sentimental value item, how to handle that tangible personal property. Number 12 is special needs trust. That would be applicable if a beneficiary or heir of yours has special needs, perhaps is getting certain government benefits, and you want to leave that inheritance to that beneficiary in a way that doesn't jeopardize their government benefits. You'd want to take advantage of this number 12, the special needs trust provisions in your will. Number 13, you may want to include a provision as to whether death taxes will be apportioned to the recipient. Grandpa leaving $100,000 to his grandson, Grandpa's estate may owe some death taxes. So does Grandpa want grandson to get $100,000 no matter what, and the death taxes attributed to that $100,000 are paid out of the remainder of Grandpa's estate? Or if 20% of Grandpa's estate, after all the calculations are made, goes to the IRS, should grandson's bequest of $100,000 be reduced to $80,000? So the net grandson would be $80,000 because the death tax attributable to that $100,000 bequest would be taken out of that bequest. Number 14, how debts will be paid. Some people leave their house or their car to certain people, but when they pass away, there's a home mortgage or car loan or reverse mortgage or a home equity line of credit. So do you want that person to receive that item subject to the loan so that that person will have to keep making that payments or provide for the payment of that debt somehow? Or would you want the debt attached to that item paid out of the residuary of your estate so that recipient or beneficiary receives the item free and clear of any debt? That's number 14. Number 15, how to do a charitable bequest. I love it when I see people leaving things to charity. 2 ways to do it. You can leave it to the charity's general fund, or you can leave it to the charity and specify that money is to be used for a particular charitable purpose that the charity has. For example, you could leave things to a school, a university, Or you could say, I leave it to a university to be specified to, for a scholarship in this particular department of the university. So you can specify if you want to. But oh, by the way, on those charitable bequests, not a bad idea if anything you leave to charity comes from your traditional IRA. Charities don't have to pay income tax when they get it, as opposed to leaving your traditional IRA to individuals where they would have to pay income tax. Number 16, providing for contingent beneficiaries. So like I said at the beginning of the video, we don't know. You may prepare your will when you're 56 years old like me, but you may not pass away for 30 or 40 more years, so we got to cover certain contingencies. It's likely it's very possible that some of the people that you name in your will may pass away before you, particularly when you're leaving things for your spouse. Your spouse is probably somewhere in the neighborhood of the same age as you, so don't just leave it as, I leave everything to my spouse. You need to cover that contingency. What if your spouse dies before you? So your will should address, I leave such and such to my spouse, but if my spouse predeceases me, I leave such and such too. You got to fill in the blank there. All right, number 17 is a simultaneous death provision. It can be a big deal and make a big difference if you and one of your beneficiaries, whether it's your spouse or one of your children, or anyone for that matter, included in your estate plan, if there's a simultaneous death, then your will, within certain limitations, can presume who died first and who died second, and that can make a big difference in how things play out. Number 18, you'll always want to name an executor and name an alternate executor. That's one of the most important provisions for writing a will, is designating who's going to be in charge of settling your estate and honoring the wishes that you have described in your will. So you want to name an executor. Great idea to name at least one alternate executor as well. Number 19 is, don't see it much, don't do it personally, but you see it in wills sometimes where the person writing the will makes a recommendation as who should be the attorney for the executor. I'm not real crazy about that one. The executor ought to be able to go get their own attorney that they choose. By the way, that recommendation is non-binding anyway in most states. Number 20, a statement in your will authorizing your executor to act under your state's informal probate proceedings. Many states have said, if in your will you state that your executor can act under these informal probate proceedings, it simplifies the probate. It doesn't eliminate it. But for example, if your executor needs to sell your house after you pass away, if they can operate under the informal proceedings, they don't have to get a judge to approve that particular sale. Whereas if they're not operating under the informal proceedings, it's likely that they will have to get a judge to approve the terms of the sale from your estate. Number 21, a statement waiving the bond requirements. And nothing can be more of a hassle than your executor or your administrator or your guardian or a trustee that you named. Nothing can be more burdensome than that person having to go post a bond to fulfill those requirements that you gave them. So you want to make sure most people waive all those bonding requirements. Number 2, name a guardian for your minor children. This would apply if you either have or may in the future have minor children. You're going to want to make sure you designate who's going to be those backup parents to my children if for some reason I pass away before my children reach the age of majority. Another provision that I think is real good, because we don't know exactly who the beneficiaries will wind up being, because again, you may pass away decades later after you write your will. So a default provision that says, if someone inherits from me and they're younger than, maybe you put 18, maybe you put 21, then their portion will be held in a trust until they reach age such and such. A default provision like that can keep the courts from having to oversee a young beneficiary's portion. Anytime you can avoid the courts, it's generally a good idea to do it, so that default provision can come in real helpful. Number 24, a no contest clause. You may want to consider it, especially if you have a beneficiary that you feel is very adversarial and very litigious and is gonna go nuts fighting for every nickel that they can fight for, whether it's realistic or not. That no contest clause, there's different versions of it, but essentially it says if someone contests the validity of your will or contests a certain provision in your will, then they get nothing. So it really discourages people from making that estate settlement really litigious. Number 25, the little known testamentary power of appointment. Maybe someone else created a trust and you are a beneficiary of that trust, and that person gave you what's called the testamentary power of appointment, a power to appoint where your interest in that trust goes when you pass away. And oftentimes that power needs to be exercised in your last will and testament. That's why they call it a testamentary power of appointment. And then numbers 26 is you want to make sure all of the required signing language and any notary and witness requirements are fulfilled. I'd hate to see you go through all this difficulty getting all this in place and then having it rendered invalid because you didn't meet either the notary or witness requirements of your state. Now, last point, kind of as an asterisk, is many people, leave their estate to their heirs, to their beneficiaries, not necessarily through a last will and testament, but they leave it through a revocable living trust. So virtually everything I mentioned in these 26 provisions to include in your will would also be relevant if you were leaving your estate to your beneficiaries through your revocable living trust. You may use a few different terms, like in a will, the person who oversees the settling of the will is called the executor, where the person who handles the trust distributions of your living trust after you pass away is called a trustee or a successor trustee. But the concepts that I went over in these 26 provisions to include in your will are also applicable if you have a revocable living trust. Okay, we went through a lot. I hope that helps. Give me a quick thumbs up. That helps me a lot. Make sure you subscribe and hit the notification bell. That way you don't miss anything. We'll see you next time.